I think the biggest challenges that we are facing at the moment are twofold. One is related to the revision of our regulatory framework, and that is covering seed marketing, it's covering plant health, phytosanitary requirements, but also then intellectual property rights, plant breeders' rights, and there is also an evaluation of the GM legislation. So basically all the pillars of our regulatory system for seed in the European Union are currently under review. So that is the regulatory area where we indeed have quite a challenge to also, as an industry, work and provide input to the different decision makers in Europe on all these items at the same time. And at the same time, to regulators that are not that familiar with the technical aspects of our industry. I think the second area that is often forgotten is indeed the revision of the Common Agricultural Policy, which also has an impact on our business framework, so on the competitiveness or relative competitiveness of the different crops. So indeed our business environment in the European Union also changes. So that is another challenge that we are currently facing. I think the main issues that we have been addressing here is, on the one hand, the interface between patents and plant breeders' rights. This has been the item of discussion in the ESA over the past almost 18 months. But in particular, over the last year, we have made quite a lot of progress to a final position on that interface, which has been presented here in Budapest during our General Assembly, and which we have discussed with regulators, but also with practitioners over the past 12 months, and where I think we have found a fair balance on how these two different legal systems can be brought into one line to the benefit of breeders as well as inventors in the area of biotechnology alike. So that definitely has been the core item of our conference. The other part that I already mentioned is indeed the overall review of our legal framework for seed marketing and phytosanitary requirements. Here as well we have provided extensive input to the regulations and to the proposals of the European Commission, and we hope that we will see indeed these coming through in the final legal proposal that the Commission is going to publish within very likely over the summer of next year. Here of course the input is on the one hand general, so covering all the different crops, but it's also quite technical and crop specific. So bringing these two areas, on the one hand a harmonized legal framework, and on the other hand crop specific technical items together, has been quite a challenge. So that I think has been the second part. The third, that is always recurring of course, is our discussion on what is the impact of the regulatory system or non-regulatory system in Europe on GMOs. What is the impact on our business, and in particular in Hungary, where we have seen problems with the alleged presence of GMOs in fields, is a very fitting place for that debate. This year in Hungary more than 6,000 hectares of maize have been destroyed just because there was allegedly a presence of a GMO. That has never been proven, but nevertheless millions of euros have de facto been plowed under on Hungarian fields, losses to Hungarian farmers, but then obviously also to the credibility of our sector, despite the fact that there is indeed still no proof that such presence has ever occurred. So these three items I think have been very much at the forefront of discussions. I think our stance is a typical stance for a science-based industry. So we look at that as a technology. It's one additional tool in the breeder's toolbox. And that tool has proven to be a mighty effective one worldwide. And the uptake of the technology in other parts of the world is just a perfect demonstration how useful this technology is for farmers and breeders to combat very specific challenges in their respective crops. Now, Europe's regulatory system in that area, as we all know, isn't working. We have no authorizations of such crops, so there's a growing divide between the regulatory situation in, for example, the United States, Canada, South America and other parts of the world, and what is happening here in Europe. So more and more, indeed, the seed industry is exposed to a situation where the presence, low-level presence of such crops in our conventional seed poses us at a complete risk of being considered in breach with European legislation. The zero tolerance policy of the European Union is clearly something that is completely unacceptable to us. We also see this as, I wouldn't call it a test case, but it is in any case something that provides a little bit of a, it is something where we see that if we don't defend this technology, maybe we might lose other modern plant breeding technologies in the future. There is currently a debate in Europe on these new breeding techniques, cisgenesis, synthetic biology, reverse breeding, and many more, and whether or not these should be classified and regulated as GM crops. If there were, we fear that the outcome would be similar. The absence of these technologies from Europe, large level imports of resulting crops from other parts of the world where these techniques will be adopted and implemented and regulated in a much more pragmatic manner. I think there's a number of reasons that come together. On the one hand, I think Europe, and I should rather say Europeans, still have the feeling that we are living, as far as agriculture is concerned, in an era of surplus. For many decades, the European Union was known for its milk lakes and butter mountains, so indeed for overproduction. And I think it is fair to say that Europeans still have not appreciated the fact that by now, Europe is by far the largest importer, net importer of agricultural products in the world. So we actually can't feed ourselves. We live off increases of production from third parts of this world. And many of those increases are based on the use of GM technology. But that is something that has been absent from the European political discussion for quite some time. And maybe we also need to appreciate that indeed in Europe we have had major issues as regards regulatory systems for approval of technologies in relation to food. You will remember the so-called mad cow disease issue, where for also quite a period of time scientists, politicians, regulators have reassured European consumers that there was not a safety issue, and suddenly there was. So there is a skepticism of Europeans towards regulators as far as food safety is concerned, generally. So that is not specific to GM technology. But definitely the opponents of this technology have also identified it as a means of business. Many of our NGOs have the anti-GM campaigns as one of their main areas of income. So I think if we look at it from a business perspective, being anti-GMO in Europe can make you quite a bit of money. It's difficult always to have brief analysis of very extensive judgments of the European Court of Justice, or in this case the European Board of Appeal. But I think it's fair to say that it is a quite principled decision that establishes the line that was drawn between breeding techniques that are governed by the classical plant variety rights system, so where indeed resulting crops would be protectable, but under the classical plant variety rights system, and those technologies that would indeed potentially result in a patent for a biotechnological invention. Simply speaking, the European Board of Appeal has decided that all those techniques that involve the classical step of crossing and selections are indeed technologies that could result in protection under the plant breeders' rights system, and under the plant breeders' system only. So it also has established that where these techniques are being employed, the resulting products are not patentable via the patent system. It is not explicit in all details, and very likely, as all court cases, there will be some questions resulting from it. So what we can expect, I think, is further cases in the future that will further interpret, let's say, the borderlines of the broccoli decision. But it's an important base, and it has been incorporated in our IP position for the future discussion about that interface between plant breeders' rights and patents. I think the main outcome indeed was a an expression of satisfaction. Most breeders, irrespective of the crop they're active in, are very happy with the way that the community plant variety rights system is being set up, and in particular is being managed by its community plant variety rights office. And I think the record indeed is impressive. The system is only 15 years old, and already today it's the largest system of its kind in the world. And it's growing impressively also year by year. I think at the same time there have been a number of suggestions for improvements. Many of them are rather technical, so they are considering procedures, usually also the way that fees are being used, but these indeed are also an expression of indeed improvements in data processing, data handling, the way that indeed the office interacts with the breeders, although also here there is a general satisfaction with this, let's say, customer or client relationship that the CPVO has established. I think there have been two major areas of concern expressed during the evaluation, and they are also being identified as those areas where improvements are required. One is the area of farm-safe seed, where it's become very clear that a weakness of the European legislation is the lack of enforceability of the provisions that are in the regulation. Without information on the use of farm-safe seed, breeders cannot enforce their rights. And there is no support from either public authorities or indeed further implementing legislation to help breeders in enforcing these rights. That is a clear weakness of the current system that needs to be addressed in the upcoming review. The other part we also briefly touched upon is indeed the interface between the patents and the plant breeders' rights system. Here we are talking more about how can we improve access to information, what varieties also contain patented elements, so that breeders that make use of our enshrined principle of access to plant genetic resources for further breeding can actually implement that in practice without unwittingly the infringements of somebody else's rights. We are discussing this issue on a regular basis between the secretariats of the European, but also the other than regional seed association, but also with our colleagues in the ASTAs, in the American Seed Trade Association, in the framework of ISF. And I think we have very often come to the conclusion that there are a number of classical areas where we can work together. One is obviously phytosanitary requirements. We are seeing an increase, obviously, of trade between different parts of the world that still today have very different phytosanitary requirements, for good reason. But if we want to open up those markets for trade and make sure that indeed genetic material can be used both for breeding and then later on production of new plant varieties in different parts of the world, then we need indeed to have phytosanitary requirements that enable the flow of seed around the world. Here we cooperate in particular at the level of the IPPC, the International Plant Protection Convention. We regularly organize side meetings during IPPC conferences together with the American Seed Trade Association, with ISF and our partners in Africa and in Asia. And they have been here in Budapest with us, and we have been discussing just these items. But there are other hindrances to market access. On the one hand, we have seen an impressive growth of movement of seed and plant material around the world. But I'm convinced that that could grow even faster if indeed the regulatory structures in the different parts of the world would allow for it. So here again, it's partly a matter of exchange of information, being aware of the requirements, following up on those requirements, making our members aware of what they need to do, how they need to prepare, if they want to indeed move material from one country to the other. And that is leading over a little bit to an item that has also been discussed over the past 2 days, and that is the area of biodiversity and the new rules and regulations that we are either already facing or maybe facing in the future as regards, for example, certificates of compliance with the new provisions of the either FAO International Treaty on Plant Genetic Resources or also most famously of the CBD. So these are also classical areas, I think, where the regional associations have to play a role because they usually serve as some form of an interface between the international level and the national level. So here we have still a lot of work to do together. Well, I hope you will, but we have to say, I think on the one hand, Europe has quite an impressive record of bringing by now 27 countries, and if we count the countries of the European Free Trade Alliance in, that largely have taken over European legal frameworks, almost 31 countries are working with the same regulatory framework. So we have seen an impressive growth of a common body of legislation. At the same time, we have over the past decade, I think, seen that there are weaknesses in the implementation of that common body of law in the different member states. One of the reasons for that is that in the past we used to work largely with what we call directives, which do require an implementing legal act on the base of the member state. And there, of course, indeed then different structures, different authorities and different histories come together and have led to some weakening of that common body of law. So now what we see is an increasing use of the tool of what we call regulation. And that means a legal act that has a direct applicability in all member states. We hope to see this fact will improve the way that indeed this common body of law is also then practically implemented within the different parts of the European Union. So I think we are confident that indeed we can see quite a bit of additional harmonization in the European Union. But at the same time, we also have to admit that there are counter tendencies. If we look at the way that, for example, now the European Union proposes to hand back power for the authorization of GMO plantings to the member states instead of, as it is today, decisions being taken at Brussels level, that is a worrying example for us, because what we have seen in the past, of course, is that then indeed we have also a regional level that gets involved. We are seeing a patchwork of legal provisions being employed, and that is usually something that such an international, globalized industry as the seed industry cannot really work with.